I will now call the case of State of Kansas versus Charles Hunter, 128056. Counsel, you may approach.
May it please the court, the state appears by Deputy Solicitor General Chris Elsleger.
May it please the court, Joseph Dash appears on behalf of Charles Hunter.
Thank you. Mr. Elsleger.
Just a little awkward for me to be on the other side. I'm not over there.
Yeah, I'm not used to reserving 3 minutes for you, Mr. Elsleger.
Yeah, yes, Your Honor. I did request 3 minutes of rebuttal. This case, the state contends that the Court of Appeals reached the wrong decision simply because it misinterpreted KSA 223430. The plain language of the statute says that a defendant can be committed for psychiatric care and treatment in lieu of confinement or imprisonment. It does not say in lieu of sentencing, but that seems to be how the Court of Appeals interpreted the statute. But the statute plainly contemplates a sentence of confinement or imprisonment first, and then commitment for care and treatment in lieu of that confinement or imprisonment. So the state contends that a correct reading of the statute leads to the conclusion that the district court may do exactly what it did in this case and sentence a defendant to imprisonment according to the sentencing guidelines for the crime of which he was convicted, and then following the statute, commit him to care and treatment in lieu of that sentence of confinement. I'm not quite sure how the Court of Appeals got to the position or got to the idea that the statute means in lieu of sentencing, but the state contends that it was error.
Could it have been subsection C that talks about the defendant's appeal rights? And I'm quoting, says in the same manner, so they have a right to an appeal in the same manner and with like effect as if a sentence to jail or to the custody of the Secretary of Corrections had been imposed.
Well, I think that's—
What do we do with that language, I guess?
Well, a couple things. First, reading the kind of the structure of all these statutes together, I feel like it contemplates the possibility of either commitment pre-sentencing or post-sentencing commitment in lieu of confinement. So I think the legislature was covering all the bases. Also, I think they wanted to make sure that no one was confused, or the state couldn't make the argument if a person was sentenced and then confined, that they couldn't then appeal that because they weren't actually in KDOC custody. They weren't serving a sentence. They were committed. So I think that protects. That's just a fail-safe measure by the state to protect the appellate rights of the defendant, to make sure that there's no misunderstanding about those. And like I said, there's provisions of the statutes. Like I say, you could read either way, and I don't think they're mutually exclusive of either committing a guy before sentencing, because another statute says that if the doctors determine that he can be, that no further help will come from having him committed, he can go back to the court. One of the options is that he can be sentenced. So I think there is the contemplation that it could happen before sentencing. But when you read that plain language in lieu of confinement or imprisonment, I think it also contemplates a post-sentencing commitment. And quite honestly, at the end of the day, this is the real head scratcher for me, because I inherited this case from one of my colleagues who retired. So I just came into this after the petition for review had been granted, and I'm just wondering what is the harm here? What does it matter one way or the other for the court? Because the statutes very clearly say that however long, if he gets committed, he cannot be committed for any longer than the maximum term that he would be sentenced to incarceration for. And any time that he's spent committed will count against any prison sentence. So there's no getting committed. It doesn't expand. It doesn't lengthen any of the time that the person is in custody.
It actually could in this case, because the sentence was for 130 months and the maximum term provided by law is 136 months, right?
Well, that is, yeah, and that's one of the reasons why in my mind, I believe that the statute contemplates a sentence being imposed first, And
What
then,
about that provision that I just read from, though, that it talks about that the court directs the defendant be detained in the hospital and no period of detention under this section? I mean, doesn't read as though the defendant would be serving him. Because it talks about the detention not exceeding the maximum term of law. So that suggests to me there has been no sentence. In other words, why wouldn't it say no period of detention shall exceed the sentence imposed?
well, I guess that's one way to read it. I read it as meaning you can't exceed the maximum term that has been imposed by the court according to the law.
That's not what it says. It says
Okay.
maximum term provided by law.
And I guess
Crime of conviction.
okay. Well, if you read the, and I read
Doesn't it?
Mr. Obermeyer's brief, I came to the same conclusion: is how do you know what we read that as me? How would you even know what that was unless there's been a sentence imposed?
Because you look
You're
at the
saying just
statute.
the maximum possible sentence.
That's what it says. And
Okay.
again, I'm confused by this entire case because in part, I tend to agree with you that while it's important to get the law right, I'm not sure that there's any significant practical impact of which comes first, sentence or commitment. However, there might be a practical impact. And in this case, the state's arguing for a view that limits the term of confinement to 130 months. And it strikes me, and I'll ask defense counsel about this, the position defendant has taken may actually add 6 months to his period of confinement.
Well, I could see how that interpretation could be arrived at. The entire statutory framework is not, it's not entirely clear. That's why I felt like reading it all, that the statute seemed to contemplate either a pre or post-sentencing commitment. And I'm not sure that it really matters. And in this case, then you also have to wonder, I mean, this is what the defendant asked for. He asked to be committed. And he was at the time already committed. He had a prior sentence for crimes committed pre-KSG, an indeterminate sentence. And he had been serving, as far as I understand from the record, all of that time at the Lorna State Security Hospital because of his mental issues. So then when this case came up, the battery on, I think it was battery on a corrections officer, he asked that it be served, that his sentence be served in commitment at the Lorna State Security Hospital. The state agreed. And when he got what he wants or what he wanted, I'm honestly, in some ways, I'm not sure why we're here, other than perhaps
Well, the
just to give
state
this.
filed a petition for review,
Well,
right?
I mean, I think just to clarify I guess to clarify the law, to give the lower courts clear guidance on what they can and can't do. I think the way the law reads, it says in lieu of confinement or imprisonment, which implies that there has been a sentence of confinement or imprisonment. I think the Court of Appeals was wrong to say that the district court was wrong in light of that language. But at the end of the day, however this case comes out, I don't think it's going to have any substantive impact on the defendant, other than he may have a potential sentence hanging over his head, which I wonder why he asked for that. But as you've identified, it could extend his sentence if you were to read the statute that way. I don't think that's what he wants. But regardless, I think at the very least, this court could clarify the statutory procedure so the courts know. And my reading of it is the court has discretion to do this pre-sentence or post-sentence, and so there's no error here. And if there are no questions,
I have one more statutory question about a provision we haven't talked about yet. And I think it's 223431, which is some of the procedures about what happens when there's a commitment. And then there can be a hearing, and that's subsection C. Statute says that at that hearing, the defendant shall be, and then it has a list, sentenced,
Yes.
committed, granted probation, or assigned to community corrections. Doesn't that suggest that committal is a different thing from sentencing?
Well,
Different disposition. You don't get both. You don't get a sentence and a committing. You get one or the other.
well, this is what I was referencing kind of indirectly earlier when I was answering Justice Wall's question, is that it seems to be a catch-all that again, my reading of the statutory scheme is that there seems to be discretion with the district court to grant, to commit someone before sentencing or post-sentencing. And this just covers all the bases and says that at the hearing, then the court can consider all of these options based on the context of the case. That's the best I can answer that. I think that if you look at 223430, the plain language in lieu of confinement or imprisonment suggests that there has been a sentence of confinement or imprisonment, because before sentencing, there is no confinement or imprisonment in place. But clearly other statutory provisions that are related do seem to hint at the idea that, or suggest that someone could be committed before sentencing. So my take from that is that the legislature intended for the district court to have discretion to do it one way or the other, and that there's no error one way or the other. And I think that the facts of this case show that there's no error, because to me, there's no substantive change for this particular defendant. He's going to remain at the Florida State Security Hospital, and he can't remain there any longer than the maximum length of a sentence. So if there are no further questions, I would simply ask that the court reverse the decision of the Court of Appeals and perhaps clarify the statute for the lower courts.
Any other questions, colleagues? Thank you, Mr. Elzler. Mr. Dash.
Thank you, Your Honor. The state's position ignores the interpretive case law that's been laid out for this particular statute and all three of the particular statutes we're talking about. There is a Court of Appeals case, State versus Smith, that says that you have to have this done first, and sentencing is taken up afterward. Let me just put it this way in the first place. And Al, actually, I'm going to answer Justice Stiegel's question. What does this give Mr. Hunter? It gives him hope that he can get out. And he's been in prison for 48 years. 48 years since he was 16 years old. He has had no hope at all until now.
How does it, I mean, setting aside the psychological impact, articulate the hope that he may serve less time in confinement?
If you consider the provisions under which he was sentenced or should have been sentenced, you don't get to 3430 without going to 3429. You must have that evaluation first. And that evaluation must come before sentencing, period. That's what the interpretive case law says, and that's what Harkness took up when it echoed the holdings of Smith.
Right.
And Harkness was from this court. So
let's say the sentence is vacated. That's what you want, right?
That's exactly what, yes.
And he's serving his he's committed.
Yes.
And he can be committed up to the maximum of the maximum term of a sentence as provided by law. I think that's 136 months, right?
Right.
So I mean, he could actually serve more time in commitment than he was actually sentenced, than the sentence you're claiming is illegal, right?
Yes.
And even if he didn't serve that time in commitment, he's not free to go when the commitment's over. He has to come back and be sentenced.
Or allowed to be free. That under 3431, the sentencing judge, has the ability to let him go. That's one of those options. They can determine that he needs to be sentenced, determine that he can be released. So that's his hope. It's not just, and here's the problem with all of this. The Court of Appeals decided it was a statutory interpretation question. And I would also suggest it's an ambiguity question, because there's no, in the time and manner, how much time is he going to serve? Well, is he going to serve 130 months under the sentence, under the criminal sentence, or is he going to serve an indeterminate time until he gets better? Their time, that's ambiguous. Manner, is he going to serve his entire sentence in the Larned, or is he going to be allowed to get out and go back to prison? So the time and manner are both ambiguous. And ambiguous, we've been doing this since 1853. Ambiguous is, can it be understood in more than one sense? So that sentence can be certainly understood in more than one sense. That's ambiguous, as well as it didn't follow the statutory procedure. But the point being, and I looked back into this a little deeper to try to figure out why review was granted, because I think if you look at the statutes and look at the Court of Appeals decision, it's right. It's correct. It's proper. If you look at the three statutes under which he was committed and how that process works, it's independent of sentencing. In lieu of has always meant in place of or instead of. And that's exactly what the Court of Appeals said. And that's exactly what every definition that I looked up, I tried to find different places. I go back to Bouvier's law.
Would you agree with me that in this case, your client was sentenced first and then committed?
Yes and no. He was sentenced in one proceeding, and I have the proceeding. There was an anticipation he was going to be committed, and there was also this odd sentencing thing, but he was committed in the same period of time that he was
Right, but
sentenced.
the sentencing came first. That's the whole gravamen of your claim.
Yes and no. And I'm sorry, I didn't mean to interrupt you.
No, that's okay.
If you go to this court's decision in State versus DW, the case was that the judge changed her mind, and before the sentencing was over, fixed the sentence to clarify it. That was in DW Williams. I was here for that. This court said, court can change its sentence or change the character of its sentence while they're still sitting there, as long as it's not modifying entirely. So in DW would say, if you do this all in one sitting, then it's all one sentence. So that being said, I also want to hit up one other issue of preservation here, because the state in its brief did not bring up the definition of commit. It did not bring up this stuff. It did bring up three things. It brought up first that the parties agreed to this. Well, the parties can't agree to an illegal sentence, and the district court can't oblige them in giving one.
Trying to figure out what makes this, let's assume that this sentence is illegal. And I want to
Why is it?
understand what portion of it, because it seems to me there's two things. One might be the sentence as a whole is illegal because he was committed, and you can't sentence somebody after they're committed.
That would be my position. Yeah.
Right. But that's why the word after is key. Like, it's the timing matters. The alternative view might be there was a lawful sentence. In part, what makes it illegal is the destination. In other words, that Mr. Hunter was sent to the hospital, not to prison.
Right,
And-
because KDOC would have the only
And
authority
that,
to
I
do
mean,
that.
the outcome is very different here. In other words, this does seem like a be careful what you ask for scenario, because one reasonable view, it seems to me, is this sentence is illegal because the district court did not send Mr. Hunter to prison. And we're going to remand, and we're going to say, impose the correct sentence, and he's going to get moved from the hospital to the prison.
That's a
And that's a bad
possibility.
result from your client's perspective,
That's a
right?
possibility. And he's been there and back several times. So I don't think he's going to worry about, first off, I don't think he's going to worry about 6 months when he's been in prison his entire adult life. He wants the hope of being able to get better. And that's what he's been trying to do.
Well, where is he? Is he at the?
He's in Larned. He's been in
Okay,
Larned for,
so he's in the hospital.
yes,
He's not in the prison.
yes, that's correct.
You said he'd been in prison his whole life, but
Well, okay. he's
technically
been
correct. He's-
Confined his entire adult life.
But his confinement is in the state hospital.
At this time it is. And if you read also the, which I won't say the Casper, because there's a attachment on the brief that shows that he's not in KDOC custody. KDOC has said, we don't have him. They don't. Because, and to answer your other question, because we did the 3429 examination, it leads to two conclusions. Either you can take the 3429 recommendations and commit him. That's job one. Or you can take those 3429 recommendations and forget it. We're not going to commit him. We're going to just sentence him to prison. And so I think under the auspices of what did they do? Well, if you read the whole sentencing transcript, I'm sure you had, the idea was to place him in the hospital and where he was. And the good intentions, we all know where that takes us sometimes. But the long and the short of it is he was committed in this hearing. he was also sentenced. He can't be done, can't do both because we've started the ball rolling with the 3429 examination and recommendations. So the next logical result would be either to commit or sentence. They're not the same thing. And I can't believe we're not even arguing that. I can't believe we'd be even thinking about arguing that, but there are a few unpublished cases that I did not brief, and I will just point them out briefly. There is a case called, and I did point these out to my colleague earlier in the week. There's a State versus Goraki, which is a 1994 case. All of these interpretive cases seem to be before sentencing guidelines took effect. But that's a 1994 case. And there's an eloquent discussion about this that at the very end of this decision, and I'll give you the 1994 Can-App Unpub Lexus 382, number 7516. A court which chooses to exercise the conditional grant of authority conferred by 22-3430 to commit a defendant for psychiatric care and treatment does so in lieu of sentencing. A commitment under 22-3430 is not a sentence and should not be considered a condition of a sentence imposed. By deferring sentencing in these cases, the legislature expressed its intent that the sentencing court take into consideration not only the facts and circumstances existing at the time of the commitment, but also those existing upon completion of treatment. So this is to give the sentencing court, if it ever gets back to sentencing, another option, another thought, another consideration to take into account before sentencing. But
Can I ask you
yes.
what in terms of a remedy, maybe going back to Justice Stiegel's question, how it's framed and characterized may impact what remedies are on the table? Because if your argument is that this simply fails to conform to the statutory scheme because no sentence should ever have been imposed, a sentence under the Kansas Sentencing Guidelines Act, maybe you're suggesting this court could just vacate sentence. But if there's ambiguity, if your claim is based on ambiguity under the illegal sentence statute, it might require remand. What do you think
that
the
could have been,
paths available, and which one are you suggesting for us?
that could have been the Court of Appeals panel's thinking in just vacating the Kansas Sentencing Guidelines sentence. They just simply vacated the sentence and said the commitment is good to go. And when, if at all, he's determined to be better, then we will go to the sentencing.
Yeah, they basically reasoned that you can't have both. So
Right.
we're going to give the commitment priority.
Yes, they did. And I
But
think
why isn't the correct result to say you can't have both? We're going to give the sentence priority.
because I think
That's the correct result.
public policy is that
Well,
we
we're
don't.
not here for public policy.
Okay.
We're here under an illegal sentence motion.
Yes,
And
but
if you can't have both,
there's got to be a reason for putting people into psychiatric commitment rather than prison. And that's for the betterment of the person and the system, because the system.
but your whole argument is that if you get sentenced, you shouldn't get committed. And your
No,
client
well-
was sentenced.
He wasn't. You have to look at the sentencing transcript to understand that their idea was to commit him. And apparently it was for a period of 10 years, which can't be done under the commitment statutes. But I just think that if you take into consideration the entire thought process that the court went through and the parties went through, just to see, here's how we affect getting him back into the care that he needs. This is how we're going to do it. I have no idea why they sentenced him, because that wasn't the correct thing to do. That was improper under the statutes and under the determination of what in lieu of has meant since time began. Or let's say since 1853, when the Bouvier said it was in place of or instead of. I think that the Court of Appeals got it right. And I think that this court should either return this as improvidently granted, or or say that we agree with just initially make an opinion similar to theirs. But I do think there still is an ambiguity issue. And it, just like Justice Wall suggested, that might suggest a resentencing. But I think you're still under the framework of the 3429, 3430, and 3431 because we started there before sentencing. And when you start one process, you have to finish it. And that's all I have. If there's no further questions, I'm going to.
Any further questions, colleagues? Thank you, Mr. Dead.
Thank you.
Mr. Elslager, you reserve 3 minutes.
Thank you, Your Honor. I think that Justice Stegall has nailed why the Court of Appeals was wrong. Because as he pointed out, the sentence was imposed. And so it hadn't occurred to me, maybe because I came into this case late and wasn't involved in all the litigation before, that as what he said is that really, if you were to take my opposing counsel's, the defendant's argument to its logical conclusion, the illegal portion of the sentence, if it is an illegal sentence, is where it's being served rather than.
In other words, the state's view of the statute, as it was briefed at least, might be wrong, or if we disagreed with it. But the impact of that would be that what was illegal here was the commitment. In other words, the commitment should never have happened.
I think if you follow my opposing counsel's argument and you go with the Court of Appeals, I think that would be the case. That's not. I don't think that's what the legislature wanted. That's not actually what the state wanted in this case. To answer my question, why we're here, what the state wants is simply to maintain the status quo. I mean, that's all along. But the Court of Appeals gave us what we think is a flawed decision. It needs to be corrected by this court. But I think the procedure that the district court followed here was correct.
Well, let me just ask it this way. I understand this isn't your position, but if this court were to disagree with your position and agree with the Court of Appeals, that you just simply cannot have a simultaneous sentence and commitment. That doesn't exist in our law. If that's true, which should take priority in this case, the sentence or the commitment?
Well, the sentence came first. And there's nothing in the statute that says that even when the district court receives the report from the mental health professionals, that it has to commit him. That's to the discretion of the district court. And arguably, the district court exercises discretion here by imposing sentence, a lawful sentence. There's nothing unlawful about if he said you're going to serve 130 months incarceration of the Department of Corrections, there's nothing to be appealed there. That would be a completely lawful sentence, and we wouldn't be here. It was the next step following the plain language of 223430 that the judge shall have the power to commit a defendant in lieu of confinement or imprisonment, which indicates to me that our position is that the district court followed the correct procedure. And I guess my questioning all along was why did this defendant file this motion in the first place? Because what is he going to get out of it? As you pointed out, he's facing a lot of risk and no benefit. The state's position is that it was correct all along, and we're just here to maintain the status quo. And unfortunately, the Court of Appeals decision upsets the status quo, and I'm asking this court to return it.
Any other questions? Thank you, Mr. Elslager. This matter will be taken under advisement.